Good afternoon, class. Good afternoon. Can you hear me?
Good afternoon, sir. Good afternoon, sir.
Good afternoon,
Good
sir.
afternoon, sir.
All right. Yeah, I'd like to welcome you to today's class. And even though it's as if you guys were just enjoying yourselves, you didn't bother to know whether there's a class or not. But we have to do what we have to do so that we can achieve the purpose for which you are here. So we are going to continue from where we stopped in our last class. I recall that we were looking at customary law as a source of Nigerian law. And this is under topic 3, which is the sources of Nigerian law. And before now, we have talked about Nigerian legislation as number 1. And we've talked about the received English law, wherein we looked at the reception, where we look at the bundle that makes up the received English law. And then we look at case law as another source. And now we are looking at customary law as a source of Nigerian law. Now, if you have your course outline, you follow me the way I've just given the review of the topic that we have handled under this topic 3, you will understand exactly where we are and how you can move ahead with us. So, based on the last topic we looked at, which is the customary law, our discussion is to continue from looking at what we call validity test for customary law before it can be deemed applicable or admissible in the law courts. So, before we delve into that, I just want somebody to give us like a summary of what our last class was all about on the topic customary law as a source of Nigerian law, so that we will know how well you've been able to follow, and then it will help us to also evaluate our teaching. All right, so the floor is open for anyone who may want to assist us on that. Do we have anybody? No one?
Good afternoon, sir.
Yeah, good afternoon.
I want to give it a try, sir.
Please go ahead.
Okay. Last class you talked about customary law and you said they are laws based on usages and customs. And also you gave few characteristics. You said it must be in existence of the general time. It is largely unwritten. And you also said it differs from tribe to tribe. And you gave another characteristics that it is flexible, it is not rigid, and also it is based on customs of particular people. That means the law of this particular people or this community cannot be used in another community. And you said not all customs in Nigeria are under customary law because they have to go through the validity test before it can be judicially recognized into law. Um, that's what I can say, sir.
All
Thank
right.
you.
Who is speaking, please?
Ajibe Watimtayo, sir.
All right, that's okay. Thank you. Samuel, Stephanie.
Good afternoon, sir.
Good
Just like
afternoon.
my colleague said, in our last class, we defined defined customary law, and we said that it is a law that existed from the history of the
Are you a
people.
mass comm
And we
student?
also said that
What's coming
customary law
now?
is very, very flexible, and as the people keeps changing their law and their issues, so does the law continues to change along with the people. Then you ask the question that why should customary law be considered as a source of law? Then my colleague mentioned a lot of reasons why, and one of the prominent ones was that because of this law existed from the people, it is meant to be a source of law because the law is meant to be applied to people, and that was where we stopped in our last class.
All right, that's a very beautiful one also. Thank you. Let me take Ogini Temitope before we delve into what we have for the day.
So, sir, we talked about customary law, as others have explained. Customary law are law based on customs and traditions of different nations, different states, if we put it as in Nigeria. And we also talked about the characteristics. Customary law is based on usage and customs. Customary law is a written, that is, it can be, as you know, it's not codified. That means it's unwritten. Customary law is flexible and dynamic. Customary law is particular and it's diverse. That means it is broad. Customary law, it brings about the different customs of different countries. And customary law is unwritten. So it's very like hard to prove because you need to get like different you need to get different proofs to like you need to get different proofs to ensure that customary law is stable. So to prove a customary law, you need something like manuscripts and other things. So I feel that's why I could pick up from last class. Thank you, sir.
All right, thank you very much. I appreciate the three of you for your contribution so far in this class. Now, we'll take it off from there. One of the things that we need to know under customary law as a source of Nigerian law is the fact that we have several customs which in some way we can define some of them as abhorrent or as customs that can be tagged as what is not normal or what is not generally acceptable, or what can also be the word barbaric can also be used to describe those kind of laws. And because of that, those laws should not be generally applicable. So if they are not to be applicable, how then do we determine which of the customary laws should be allowed to be applied in our law court? And that's why the system of court in Nigeria have developed what we call the validity test. And the validity test is to help streamline the kind or the different customs that can be engaged, in our judicial system. Please give me just a minute. So, because it's not generally okay to make it open for any kind of law to be applicable, then this test is introduced. Mind you, again, we are looking at customary law as a source of Nigerian law, which is under topic 3, if you are following me with your course content, which I've already given to you. Now, example of those customs include killing of twins. You know, at a point in time of our history, twins were considered to be strange children. But the truth of the matter is that practically all of us, if not all, exactly maybe 99% of those of us on this in this meeting, we agree that twin children are beautiful children. As a matter of fact, if you have them, you discover that, especially when they are grown, you see the beauty of life that is attached to having twins. But at a time, it was considered as a taboo for twins to exist. What do we have? Then customs exist that they should be killed. There are also instances of customs like that we consider to be barbaric in nature. In some places, when a man dies, they ask the wife to take the water they use in bathing for the dead person as a just to prove whether or not she's guilty or not. So those are the kind of customs that have existed. And then we cannot, the courts in Nigeria or the Nigerian legal system cannot continue to allow such customs that have been considered to be very unfair to remain. For example, in some clime at a certain time, if you are a female child, you are not allowed to inherit the property of your father. These were customs that were deemed to be abhorrent. And thank God, when the colonial masters came, we see that the killing of twins was stopped by Mary Slessor. At least if you do not know so much about our history, you will know about that lady. And so what then do we do? Like I said earlier, for any custom, therefore, to be applicable, it must go through this test. And this particular test that we're talking about has become listed or enlisted into our legislation since the colonial time up to the present time that we have. For example, I will refer to Section 44 of the High Court Law of Lagos State. I will repeat that again. Section 44 of the High Court Law of Oyo State. Now, this law simply provides, and I quote here, it says, customary law will be applicable in the court if it is not repugnant to natural justice, equity, and good conscience. It is not customary, it's not contrary to public policy and or incompatible directly or by implication with any law for the time being enforced. That is the provision of Section 44 of the High Court Law of Oyo State, 1978. So that is to say that in that law, it has already been provided that customary law will be applicable in the court if it is not repugnant to natural justice, that's one. If it is not natural justice, equity, and good conscience, and is not contrary to public policy, and then it is not repugnant. So, therefore, you notice that this position has continually remained in our system. that therefore, before any custom can be applicable in our court and can be seen as a valid customary law, which we can refer to as a source of Nigerian law, it must pass through this test. And these tests are number one, the repugnancy test. Repugnancy test. Number two is the compatibility test. The compatibility test. While the third one is the public policy test. So, therefore, I will take our time to explain this validity test that we're talking about in the course of this class. The first one, like I said, is the repugnancy test. That is, it must not be repugnant to natural justice, equity, and good conscience. If you check the dictionary meaning of repugnant, it's something that connotes something that must not be repulsive, something that must not be irritating or some kind of a very disgusting thing. So now let's look at the first test, which is the repugnancy test. Now, this repugnancy test is one of the tests that is required that a custom must pass through, to the effect that the custom must not be repulsive or disgusting. And what now, this blessing, Peter Udo, I have had cause to meet you 3 times in the course of this class. You continue to unmute yourself and disturb this class. That is very, very unacceptable. I've just removed that fellow. If he or she should come back to this class to disturb us again, then I will take an action against the person. So, repugnancy test simply says that a custom should not be repugnant. That is, it must not be a disgusting custom. To natural justice, it must not be repugnant or against equity. That is, what is fair and good conscience. So if a custom is found to be repugnant to fundamental rules of equity, which is basically fair, then the court will have to ignore such a custom. Earlier on, I gave you an example that there used to be a custom that says that a lady, a female child, cannot inherit the property of her late father. And the question is, what makes a male child to really be of a greater importance to a female child? Or if we ask it the other way around, what makes a female child to be a lesser child compared to the male child? Of course, it was seen that that rule of custom is not fair enough, because every child, first of all, will become a human being, normal human being, irrespective of age, irrespective of height, irrespective of every other feature. The number one thing is that the individual is, first of all, a human being, which consequently deserves every form of respect that other human beings can get. So, in question, then we will say that that kind of a custom is not in consonant with the practice of fairness. So therefore, it cannot be allowed to stand as a customary law. Then what then can we say is what is fair? Or if we want to define natural justice, what can we say natural justice is all about? Or what can we say equity is all about? Or what can we say good conscience is all about? This particular word that we have deployed are capable of many meanings. And that's why we will say what is fair. What is fair to Mr. A may not be fair to Mr. B. I'll refer you to the case of Tinubu and Peter Obi and the rest when they went to the poll and the election body declared President Tinubu as the winner of the election. Now, Obi and Atiku will probably feel, of course, they have expressed the view that many things were not looked at in deciding or getting the outcome of that case, meaning that the court was not fair. But to Mr. Tinubu, who is now the president, everything that the court did is fair in his own side. So that is to say that what is fair, what we can refer to as equitable, or what we can refer to as good conscience, is relative, is very tricky to really get the exact meaning. As difficult as things are in this country now, there are people who still come out to say that all is well. As a matter of fact, I read when someone said that you cannot get a decent meal with $10 in America, that in Nigeria, that $1 can give you a decent meal. Now, the man feel that Nigerians are not suffering, that all is well. What do you expect of him? If he's the same man who is eating from the same table with Mr. President, or who is eating with the same table with the ruling party, or those who are benefiting directly from what the government of the day has to offer, that kind of a man believes that everything that is happening now is fair to all intent and purposes. So that's why we're saying that it is very difficult to say what is fair or to define natural justice. But generally, the concept of natural justice varies from society to society. Okay? Some society as something immutable, while some pay passing reference to it. In the part of the country where I studied, if you are a younger brother to an older person, you can call that individual by his name. You say, Uche is your elder brother. But in this part of the country, the western part, the Yoruba part to be specific, the issue of respect is taken seriously, that a younger one is not expected to call his older brother or sister by name. Now, to us, issue of respect is an issue. In some places, it does not matter. Whereas in some clients, you see a child who wake up early in the morning and approach the dad and say, "Dad, how you doing?" Which in our own side here, we feel that that is disrespecting or disrespectful for a child to ask the father "I" without greeting properly, as we all know. But what we are saying is that regardless of these confusions or the different meaning that can be attributed to what we are talking about, we can see that what the meaning of fairness or natural justice is has been talked about in several cases, and is to the effect that everyone should have its own cut of the general cake. And as a matter of fact, as much as possible, it should be equal or based on whatever tradition that is applicable at that particular time. And then we refer to the case of Dawodu versus Damole. In that case, what was before the court was relating to Yoruba law of inheritance. Under this custom, if a man dies without a will and he left multiple wives, his property was divided according to the number of wives he left behind. Meaning that if Mr. Ojo died and then he left 4 wives, and each of the wives, the first one had 2 children, the second one had 6, the third one had 1, and the fourth one had maybe 2. The rule of custom under that, applicable on that, with that particular case, was that the property should be shared in equal proportion with the woman who had 1 child, same with the woman who had just 6 children. But it was viewed that that was not fair, because the number of children that are entitled to what the mother will get should be put into consideration. And then the issue was that should it be that the inheritance should be shared by the children instead of having to share it by the number of the wives. And then we talk about the system of Ori Ojori, meaning that it should be divided by each child, irrespective of the number of children that the mother has. Other argument is that it should be distributed per stride, that is idigi, that is by each of the wives that the disease had when he was alive. So these were the various interpretation that were given to that particular rule of custom. But what the court in that case reason was that it was repugnant to natural justice for it to be shared among the wives without taking into consideration the number of children that each wife had, that it is more equitable, more fair, or of a natural justice for every child to have their share, directly from the inheritance. So these are, of course, when the court gave that kind of judgment, the case was appealed against. And then the Court of Appeal was saying that rule was not a proper one, because that such that doctrine can only function effectively in a monogamous society and not in a polygamous society like ours. But the question is, what is most fair in this mode of sharing? And that's why we are still saying that it is very difficult to define what is fair or what is equitable under this discussion that we are having. Another case is another part. Sorry, somebody on this platform did something to our table, and then I don't know, can this person please remove what he or she has put on the screen? All right. Okay, so let's continue. So another case that happened to, yes, Giwa Aisha, you have something to say?
No, sir, it was my phone. I'm trying to remove it, but I can't. Should I leave and join back?
That should be in the interest of this class, because what you have done now is not making everybody to see me.
Okay, sir. Sorry, sir.
It's all right. So another case is the case of Guri versus Hadejia Native Authority. Guri versus Hadejia Native Authority. In this particular custom, this particular community, there is a rule of custom that when a thief is caught on the highway, he should not be allowed to defend himself. What kind of a rule of custom is that? Because it is not everybody that you classify as a thief who is actually a thief. So if after you have apprehended the individual, you did not give him room to explain whether he's a thief or not, and you went ahead to set fire on the individual, you will have committed an error. What did the court do? The court felt that that rule of custom is repugnant to natural justice because it is actually against the principle of fair hearing. Fair hearing is that you should hear the other party. Just yesterday and today, I had case to look at a matter that was reported to me by one of our tenants. The man reported to me that he asked the security man to get something for him, and that the security man refused, and he got angry and he walked away, only for me to get a call from another source reporting that the security man was assaulted by the man who called me earlier to say that the gate security man was disrespectful. Meanwhile, he never told me that he assaulted the man to the extent that there was blood all over his body. So if I had failed to listen to what he has to say, or listen to the other party and then jump into conclusion, I would have acted unfairly. So therefore, in the case of Guri versus Hadejia Native Authority, the court said this rule of custom that does not allow a robber, an alleged robber, to defend himself is against natural justice. So that is to say, therefore, that for any custom to be applicable or to be deemed to be law, it must be such that is not against natural justice. Even though we may say that it's difficult to determine what natural justice is, because what is good to A may not be good to B. But to some extent, we have a fair idea of what is fair. One of it is that our elected leaders in this country are practically the ones taking over all the good of the land. It is our belief that, yes, you have right to some benefits, but don't take all. Let all the citizens have a fair share. What are we asking for? We are not asking that the government should pay us salary whether we work or we don't work. But we are asking that the government should provide basic amenities. The reason why many people in this country are running away is not far from the fact that we do not get the basic amenities that we want. How many of you that are listening to us now can say that there is pipe-borne water supplied by the government in your area? How many of you, I'm very sure that some people are not able to join this class because for 3 days now, they've not had power supply. I'm also very sure that as we speak now, some people's battery are in red, probably that may even go off any time from now. Why? Because they have not had power supply to charge their phones. That is what the average citizen is asking for. But what we see is our elected officials or appointed officials, they want to take it all. We've seen cases of how the former petroleum minister was taken to court. You see the kind of properties that were recovered from her. Situations where there was a rumor that there was a particular bra that was seized, that was a diamond bra. Some said the kind of jewelry that were recovered or houses that were recovered. It shouldn't be so. In the countries where our people are running to, the government is not giving them is not giving them everything, but they are able to get the basic things. And that is what where we can look at it as to determine what is actually fair or just. So, a conclusion on that number one test is that the custom must be the one that is not contrary to natural justice. Now we move on to the second test, which is the compatibility test. The compatibility test simply says that the custom must not be incompatible with any written law or any law that is in operation at that particular time. Now, there are various enactments that ask the court to enforce customary law. But the question is that customary law, is it in line with the laws of the land? I will take you back to the earlier example I gave relating to inheritance of properties by female children. Now, the Constitution of the Federal Republic of Nigeria, which is our number one law, has said that no one should be discriminated against by reason of birth, sex, age, religion, or anything. So, if there is a custom that goes contrary to what the Constitution has provided, then that custom will not be allowed to stand, meaning that it is incompatible with the law that is enforced in Nigeria, meaning that it is not compatible with written law. For example, if the Lagos people should come up with a customary law that says that no other person apart from the Yoruba people from the Yoruba extraction is allowed to own land in Lagos. That law, if it becomes a customary law, will not be enforceable because it will negate the provision of the Constitution which allows every Nigerian citizen to own property in every part of this country. So, in essence, the custom or customary law must not be incompatible with any written law. That is the second test that a custom must pass before the court of law can enforce it. The third one is what we call the public policy test. That before a custom can become applicable, it must pass the public policy test. Now, what do we mean by public policy? Public policy is also difficult to define, but Ese Malemi in his book, The Nigerian Legal System, tried to define what public policy means. In his book, The Nigerian Legal System, Ese Malemi defines public policy as public welfare, public good, public interest. Now, what is of public interest? I'll give you an example. Sorry, who is this person that is disturbing this class?
Oh,
The funniest thing is I cannot even see the person on the chat on the participant list.
My phone.
It's sad. Some people are not in this class physically. And that's why I frown when anybody fails the course. You now go about meeting the lecturer, begging lecturer. It's not something that should be heard of. Because when you participate actively in a class, you get the gist and you're able to write your exam without any form of assistance and you pass. Please, nobody should disturb this class again. So, Eze Malemi in his book define public policy as public good. Now, what is of public good? What is of public interest? Our society, for example, does not permit anybody who in his right senses to dress indecently. No society permits that. So why is it not allowed for people to dress anyhow in the society? It's simply because it can corrupt what we call public morale. Yes, everybody, we have our freedom to do what we have to do. But that freedom is not absolute. You cannot be walking on the road practically naked and you say you are exercising your freedom. The society frowns at that. Why? Because if you do that, a time will come that people will practically not wear anything to work in the society. And when they do that, it can cause a lot of problem for the society. As a matter of fact, it can be seen as height of immorality. And then it can lead to cases like rape, cases like indecent assault, and so on and so forth. So, what is of public good is that everybody is expected to dress decently in the way that when you are exercising your rights or freedom, it does not affect any other person. That's just an example. But what we are saying is that any customary law or any custom that does not seek to protect public good should not be allowed to be applied as a customary law. Okay? And so, like I repeat again, any custom that is found wanting in any way as to assault or rape public policy or public welfare, which by virtue of section 14 sub 2, paragraph B of the Constitution of the Federal Republic of Nigeria, such law will never be allowed to be enforced in our system. Because section 14 sub 2, paragraph B of the Constitution of the Federal Republic of Nigeria 1999 provides that the security and welfare of the people shall be the primary purpose of government, meaning that government has a duty to protect us, to seek for our welfare, and to ensure that practically we are fine as citizens of this country. So therefore, public policy means public morality, it means public security, it means public welfare if we are to go by the provision of the Constitution as stated in section 14 sub 2 paragraph B. So a custom will not apply on the ground that it is against public policy, meaning that it must not be contrary to public policy. So in this case, therefore, we need to know that no individual, let me even bring this example under this topic here, that no individual should be discriminated against. A man is married to a woman, and he will say, this woman is my wife. And then the woman, of course, gave him children, had about 5 children. And the man went outside to play other games and impregnated another woman. And then you bring the woman conceived and gave birth to a child. Then you say that child is a bastard. That's the name that is coined for it, because he's not giving birth to through a legitimate marriage institution. But the Constitution of the Federal Republic of Nigeria says that nobody should be discriminated against by reason of his death, of his birth, because the truth of the matter is that that child did not in any way give birth to himself, and therefore he is supposed to have the same rights with the one that were born in the course of the marriage. But there is a caution there, in that if you allow it to happen that way, that a man that is married to a woman in a monogamous family will still go outside to be having children, the fear is that if it is allowed to stand, it will corrupt public decency, meaning that people will just be free to go out and do whatever they like. And then it will not be good for the society, because most of the children that are born in those circumstances are never taken good care of by the fathers. And then eventually they become nuisance to the society, because it is very difficult to say that a young man who does not have any sort of provision should not steal. And that's why they push themselves to stealing, even though they could have looked for other legitimate means to look for food, even as bad as going to beg for food. But many people will not engage in that. They rather engage crime, and then they go ahead to commit all sorts of crime in the society. And then it becomes a problem for the society at the end of the day. That's why the society will caution such actions, even though at the end of the day, the society or the law of the land will not prevent that child from having some form of rights on his father's property. But the society does not also encourage promiscuity. The society does not encourage infidelity. So our laws ordinarily should not support infidelity, should not encourage it, or should not encourage anything that can bring the society to disrepute. So in conclusion, on customary law as a source of Nigerian law, we want to establish that customary law is one of the important sources of Nigerian law, because it governs, so many issues of concern of life of us as a people. Like, for example, customary law covers issue of marriage, covers issue of succession, issue of inheritance, even land tenure system, and even chieftaincy matters. So because of how important they are, or the customary law is to us as a people, it will continue to remain as one of the major sources of Nigerian law. Just that those that are against natural justice, those that are against good conscience, those that are against equity will not be allowed to stand, as much or as long as a rule of custom is not against any of these 3 tests. Then such a custom is seen as a valid law and one of the laws upon which the society stand till date. So with that, we bring the lecture on customary law as a source of Nigerian law to a close. But before I go, I don't know if there is anyone who may want to have a question from this particular lecture. The floor is open, and then we can ask our question. No one? Any question? Okay, so I want to believe that the class was well taught and is well understood. So on that note, we call it a day here. And then when next we meet in this class, we will take on the next topic, which is the Islamic law. But for those who may have joined just as a way of having this class to refresh their memory or to learn ahead of their class, we just looked at part of topic 3, so that when we get there during your own classes, you'll be able to understand what we are saying better. So in the absence of any question or contribution, we call it a day here. So please do take care of yourself and enjoy the rest of your day. Thank you, and God bless you.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir. God bless you, sir.
Thank you, sir. God bless you, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir.
One thank you don't do. One
Thank
thank
you,
you don't
sir.
do. My love now they say one thank you. No.
Thank you, especially those ladies. Thank you so much, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir.
I'm sorry for the
Thank you, sir.
Thank you, sir.
interruption. I'm very sorry. I didn't know I muted my video.
We have questions, sir.